Everybody, good evening. It is 5:30, so let's call this meeting to order. Marnie, will you please call the roll?
Councilmember Steve Friedman.
Here.
Councilmember Deb Gillis.
Here.
Councilmember Anna Richards.
Here.
Vice Mayor Sharon Mahoney. Here. And Mayor Don Horton.
I'm here.
We have a quorum.
Let's see. Captain Ed Davison, would you please leave us in the pledge? Thank you. Okay, are there any requests for deletions or emergency additions? None over here, none over there. All right, I would like to, if you guys are okay, I'd like to move our motions, especially, well, number A, the resolution on the charter review, in case everybody's watching and all that, to resolutions, which would be 9, because we have no resolutions tonight. Is that okay with all of you guys? Okay.
So moving the motions up.
Excuse me,
Just
I'm going to
moving
move the motions
up
up to item 9, which is under resolutions, but we have no resolutions tonight,
Yep.
so
Perfect, just want to make sure I was.
That's great.
made a
Okay.
good note.
yeah, why don't we do that? We could do that. If y'all want to do that, okay. So we'll get the charter review and the baseball field out of the way. You good with that, Steve? Deb? Anna? Okay, everybody's good. Let's see, let's move on then to reports and presentations. Jennifer?
Yes, thank you. So in your packet, under tab A, there's a proposed plan that was developed by the Workforce Affordable Housing Committee for potential either changes to the code that we could make or policy direction that we could do for incentives and things relative to the early evacuation affordable housing allocations. As you know, we have 292 left of the 300 that we received from the state of Florida, and haven't seen a lot of movement on those. And as you know, affordable housing is a dire need in the village, and so the Affordable Housing Committee was trying to find a way to encourage the use of those allocations, and this was something that they came up with. The first section where it talks about the A through N, that's just the regular regulations that were placed on those allocations by the state and is in our code and comp plan. And then the recommendations start at number 1. So we worked on this for a pretty good while, actually, when the mayor was on the committee, is when it started. And if I'd let him speak to that if you'd like. But we hashed it out. We talked back and forth about a lot of different things. And so these are some of the things they came up with. So I'd be happy to talk more about it with you, but I wanted to get it in front of you if you want some more time to digest it, and then we can bring it back to another meeting. But what we're really looking for is for you to give staff, my staff, some direction on where to go with some of these recommendations, if it's positive, negative, if you think we should go in that direction, or how you want to proceed. So.
Thank you, Jennifer. Any comment from anybody up here? Do you want to take this and study it and maybe call some of the members of the... I'm sorry, do you want to call some of the members of the Affordable Housing Committee and talk to that, or just take this and consume it? Is that, Deb?
I would prefer to take and consume it tonight, not talk about it.
Okay. Steve?
Yeah, I agree. That's
Okay. All right.
And
So,
just the Affordable Housing Committee next meets on February 2nd. If there's any interest, we might be able to do a joint meeting if there's enough council members that want to attend. I'm happy to post it as well. So if that's something that interests you and you want to talk about this, let me know, and I'll be happy to post it as a joint meeting too. So
okay.
we can do that as well.
What
All
time?
right, good
what
deal.
time is
I- you
They
know,
meet at 5 o'clock.
one thing I noticed is there might be a little bit of a conflict between item 9C and number 3, but other than that, we could talk about that. So I think it's the best thing to do is to take this and kind of
Okay.
figure it
perfect.
out and give the committee a call or talk to some of the
Excellent.
peoples in the committee.
Okay.
Great.
I'll wait to hear from everybody then.
Great. Thank you so much.
Thank you.
We have nothing scheduled for our Citizen Advisory Committee reports. Any mayor and council communication from anyone? You guys are really ready to go to this game, watch this game, aren't you? It's all about you, isn't it? Okay. Village attorney.
Yeah, blame the guy who didn't go to Miami to bring something up, so.
That's okay, I'm a Texas Aggie.
Oh,
so-
okay, there you go. I'm UCLA, so we weren't anywhere near the college
Okay.
playoffs this
Good
year,
deal.
or reading time recently. So I'd emailed you all the other day, or yesterday, I think it was. It came to our attention that, if you all recall, there was an opinion called the Shands decision that came out against the city of Marathon. And we had previously, it's a takings case that greatly expands the when takings cases might be brought. It also shifts the use of TDRs from whether that constitutes a taking to whether that would reduce any amount that might be awarded to somebody as part of a taking. So the Florida Supreme Court recently came to our attention, recently declined jurisdiction. Marathon is planning to seek review from the United States Supreme Court. They've retained Supreme Court, U.S. Supreme Court attorney. That there's people, that's all they do, and that's what their practice is. They've retained somebody to work with them on their behalf for that. And they have asked us if we would support them through an amicus brief once they get to that point. We have supported them in the past. We filed an amicus brief before them with the Florida 3rd District Court of Appeals, and then we had previously talked about potentially doing one with the Florida Supreme Court. There's not necessarily a guarantee that we would file an amicus brief under the U.S. Supreme Court rules. It's disfavored to file one if you're not going to be adding something that is not otherwise brought up in the brief. But without getting into too much detail or strategy, I did speak with the city attorney for Marathon as well as the county attorney for Monroe, and we talked about ways, because they do have a word limit, and ways that we might be able to bring in some of the things that are outside of just the pure legal issues, like the environmental issues, the unique BPAS ROGO issues, the areas of critical state concern, that we might be able to help Marathon, and then they wouldn't have to eat into their word limit in their petition. So I wanted to see if that was something that you all were still supportive of and comfortable with, which would be us potentially filing an amicus brief to support Marathon if we had a basis under the U.S. Supreme Court rules.
Thank you, John. So really, all you need is a consensus at this point, right?
Yeah. As long as the majority of you are okay, we'll continue with the path we've been on. If the majority say, no, we wouldn't like to, I'll let the Marathon folks and the county folks know that we wouldn't be joining in.
Steve?
Yeah, I think this presents an interesting situation for us because I sent some questions to John when I got the email. And one of those was, what percentage of petitions actually get heard by the Supreme Court? That's 1%. So I think he also made some good points about the word limit, so that we could present some other arguments that they might not be because of their limitations. So that would be one advantage for joining it. I just think it's a big question of expense. Like, what is this going to cost the village to do this for a 1% chance of it getting heard? John suggested that possibly they might come up with a flat fee. Don't know what that is, but I think we need to know what the approximate costs of continuing in with this would be before we really make a decision.
I think it's a fair question, and I actually brought that up with John as well, and he was. I think he's comfortable probably coming back with a fee, because it's really just a document that you're not going to be attending. You don't have to present. It's just a document that you are going to do in order to vocalize our side of our side of, or what we think on it, right?
Yeah. So, and I got a little more clarification from my appellate partner too. So in terms of, what an amicus brief would look like, there's actually, the first amicus, there's a potential for 2 amicus briefs, actually. So the first issue is trying to get the Supreme Court to take jurisdiction. That's, are we, is this case one of the 1% that they will actually take up? And you can file an amicus brief to support that. If it gets taken up, you have the opportunity to file a second one on the merits. It's going beyond, is just why the Supreme Court should take it up. So the first one is not as comprehensive. Obviously, the ones on the merits is a little more comprehensive, but we're not even there yet. And that's, hopefully we get there because that means that they've taken the case, but we're not even close to that right now. So in terms of like a flat fee for doing the first amicus brief, he told me we could do it for $17.5. And that way, we would be all in on the brief. If they take up jurisdiction, we'd have to bring it back as to, what the cost might be, because we'd have to see what the issues are that they take up. But that would probably be a little bit more comprehensive, and the expense would be a little bit greater there.
Okay. Deb?
Well, I'm in support of us doing this. I think it's important that we stay in this game. TDRs are very important in this village, and takings and the whole thing could have big ramifications on Islamorada. So I just think it's important that we stay in this game. So yes.
Okay. Anna?
About it, because I was trying to, my thing too was the cost, like how much is it going to entail, like, because I don't want to spend a lot of taxpayers' money on stuff that technically isn't affecting us, but it could affect us, you know what I mean?
Yep.
So I think it's going to come down to time and money, really.
Sharon?
I disagree with everybody, it's fine.
Yeah, so I think there's a consensus right now that to move on, watch the costs, but we have standing in here. We have skin in the game, so good. Yes, Steve.
If that's the consensus, I'll go along with that. I would just also encourage to urge our attorney to contact Key West. I don't think they've joined in. They don't really have potential takings cases, and that might be it, but they also have a lot more resources than we do. And I think you said Monroe County is involved in it?
Yeah, and they have been, and the county attorney indicated he was going to be, I guess they've got a meeting coming up, he was going to be seeking authority for that as well. And then we also talked about getting others involved, other, I'll call them friends, non-municipalities, but municipality-related groups, whether they're planning groups or in the past, the Florida Association of County Attorneys, I think, had indicated they were going to join in. So the hope is to get others involved as well. And I should also indicate with the cost, obviously, if we determine that there is not a basis to file an amicus, then obviously there would be no cost, but I just felt I should probably mention that.
Yeah, I just think that's important to get as many communities involved on the same page as possible.
Yeah, I think Key West was probably just had their mind on other things at the time, so.
Yes, good
Deb, you
point.
still need some?
I just had a question. Didn't your email say something about we were up against a deadline, and this was about the only meeting that we could actually discuss this in before the deadline, so we need to at least say a yes or no?
Yeah, exactly. There's and sorry, I should have mentioned that. Yeah, there's a deadline for when Monroe County needs to file their petition, and there's a deadline for when an amicus needs to file. I don't have the exact dates, but we were pushing up on that, and obviously we need lead time to prepare a brief. So yeah, we were pushed up on that. And then since we're not in active litigation, we're just in amicus. We could not meet in an executive session because of that. We have to discuss it either here on the dais or in one-on-ones.
I'm seeing a nod by everybody up here, so there is a consensus for that. Okay?
All right, thank you. I'll let them know down in Marathon.
Chairman, would you consider a very brief public comment?
Well, we're going to move on to public comment right now, so why don't we just go on and head into that if that's okay. We'll move into public comment. Marnie, are there any public signed up?
Other than Captain Ed, we don't have anyone signed up.
Well, there you go. Your turn, Ed. Works out.
Okay, good news. environmental groups, major environmental groups have been involved in this already. These are lawyers that I've worked with for 25 years. Richard Grosso, whom you guys know, and some others. And I would expect, because remember the estimate is somewhere near $1 billion of takings giveaways if the folks who are in that side of things have a free hand. And we think there's lots of good public reasons why it shouldn't happen that way. This was a big surprise. The Shands decision was contrary to 20, 30 years of land use law in Florida. It was a big shock to everybody. And we think it's on shaky grounds. At any rate, there are a lot of environmental interests that are going to be involved in this, and I'll talk directly to John. I'm going to be obviously lobbying like hell to be sure that we get some muscle behind this. This should never have happened. People sort of weren't being as fierce about the issue as maybe they might have been, but the implications are staggering and way out of proportion to whatever's fair. Anybody who bought property in the Florida Keys since critical concern was declared as a public notice that there are limits to development in the Florida Keys for good, sound public reasons, environmental reasons, carrying capacity reasons, infrastructure costs, all those things. And until this decision, until Shands, there is a very limited likelihood that many takings cases would prevail as a monetary burden on the public. That's changed. This is a really serious threat, and we need to be general quarters on all this, and I'm going to do my part.
Thank you, Ed. Marnie, anyone else?
No, sir.
Nobody on Zoom?
Nope, just checked.
Very good. Public comments closed. So we'll move on to what we moved up as far as motions. This is the appointments to the Charter Review Committee. We approved the resolution last Tuesday. So I think the way, if it's okay with y'all, we're going to pick our person, that the one that we had, that we had decided. And then I think Marnie's got the other list of names. If somebody wants to add to that list of names, let Marnie know after we pick our first 5, and then we can take that list and maybe circle 2, and then see if we've got a consensus on who those are. Is that good? Yep. Good?
Yeah, just to be clear, so we'll pick our 5, and then the remaining 2, you want to do a vote on the people that have actually...
Yeah, I don't think we ought to do a motion or a second and all that. I think we ought to take that list that Marnie has and circle 2 names and see what overlaps between the 5 up
For
here.
the remaining 2 positions.
Yes, sir. Yes, sir. You good with that?
Yeah.
Okay. All right. Why don't we just start off with the vice mayor? Sharon, you want to tell us who your choice is?
Yes, Richard Black for me.
Okay. Anna?
Roger Young?
Okay. Deb? Lori Lalonde. And Steve?
Susan Raffanello.
Susan Raffanello. Okay, and I'm going to pick Ty Harris. Marnie, you got all that? Okay.
I just want to make sure that we have a complete list, because I don't know if you guys got emails that I didn't get in terms of other names on that list.
I don't think I'm not sure that I got any today, but I think all the ones that I got had sent to Marnie.
I created a ballot.
Okay,
for
very
each
good.
council member with spots for write-ins. So everyone that had expressed interest to me and everyone else that I was aware of that expressed interest was listed here. And a couple of those folks are folks you just named. But there is a write-in spot, so you can either write it in yourself or, just tell me who you want.
Okay.
Here, we'll just write it in if we, let's just write it in. It's not on the list.
If it's not on the list,
On the list, you
you
can write
can
them.
just write it in, sure.
Maybe let people know this, so they'll know that they're eligible for it.
Oh, my goodness.
Some of them are already limited.
So obviously, we can, there's a couple of them here that we can scratch off. We're not going to pick from because they're already picked, right?
There's one on here also that has said that they cannot serve.
Who's that?
I'm sorry,
Leslie Bryan.
Oh, okay, so we can cross her off?
Leslie can't serve.
So,
you're not on speaker, Dan. No,
Oh,
you
I'm-
are.
oh.
Okay. Somebody turned it on for me. How about that? Good job.
Magic. Leslie Ryan said that she could not serve.
Okay.
But Jim Ryan, her son, said that he'd like to serve.
Well, then you can write him in if
Yeah,
that's.
right.
Okay.
It's just not on the list.
And then I don't see John Lentini on this list. John, who applied, sent me his interest.
Okay.
Not on here. That was Tuesday, he sent it.
Didn't see that either.
I didn't put anybody on that I wasn't
Also-
aware had applied.
Also Marilyn Smith.
If they only sent it to one council member, I wouldn't have, put it on the list. Wouldn't
I
have
just
seen
want to
it.
make sure we have everybody that expressed interest that's at least on this list
Yeah,
for people to
everybody
consider.
should fill those in, and if anybody knows anybody else, please put them on the list.
I think that's it for me.
Yes, ma'am, two. Two names.
Yeah, and just a reminder to make sure to write your names on the top for public records purposes.
Done. No peeking? Well, let's see if there's some overlap.
so should we do something while they're looking, so can we move on to something else?
We could maybe do that. Let's see.
Unless you can do it fast. Too many names, too many names.
But, well, I think we're gonna have public comment on B, and we move that up right after that, so I'm sure she could do it fast. We may have to vote twice. Maybe have to vote again, who knows?
That's what I anticipate.
It was a big list. I didn't realize it was gonna be that big.
Surprise.
Yeah, well, that's good. I'm glad there's interest. It's a big deal.
Yeah, that's why I appreciated at least picking from the pool of people that showed interest. So, yeah.
I guess we could have brought the Jeopardy music too.
Okay, we have 3 folks who received 2 votes. So those folks would be Elizabeth Jolin, Craig McVeigh, and Joe Ralph. Would you like another round of ballots?
I suppose so,
Just get the same ones, just like,
Oh, yeah,
because
that's
it's an
fine.
even number. We need
You
an
can just write it down.
you just use the same ballots and you just circle.
So what are we circling, 1 or 2 now? Just 1? Oh, 2.
Out of those 3,
Well, what are their names?
we'll make her do it.
Oh,
So we know.
Just write the name on that side, so I don't know what it
so now we're circling 2 again, right?
How did you guys do it in the
No,
first
two.
go around? Yeah, I'm just wanting to make sure that we can tell which one is the first round.
What
Okay.
now?
Use the highlighter.
Yeah, the highlighter, that's a good
So
idea.
Either that or I suggest just writing it in.
Who's on first? No.
Yeah.
Are we voting for 2 again now?
Is it,
There are 2 positions and 3 people.
but are they voting for, you're voting for 2?
Yes, so 2,
Again.
yeah. Joe Roth, Craig McVeigh, and Elizabeth Jolin.
Okay, and you want the 2 that we want highlighted.
Correct.
Okay, Steve.
So we can
and Brown, those
differentiate.
are all those up there.
Can you two do me a favor? Oh, never mind, I have my personal secretary. Good thing she's left-handed.
Right. We have, a majority have voted for both Craig McVeigh and Joe Roth.
All right, so to recap, the committee will be Richard Brown, Roger Young. Richard Black. Richard Brown.
One of those colors.
That's right. Richard Brown has passed away. I'm sorry. He's a good friend of mine. So Richard Black, Roger Young, Lori Miller, Susan Raffanello, Ty Harris, Joe Roth, and Craig McVeigh.
Lori.
It's still Lori. Okay, very good. Lori Miller Lalonde. Lori Lalonde Miller. Sorry, Lori. I know you're watching.
Thanks to everybody for, participating and
Absolutely.
being interested.
Absolutely. Thank you, everybody, for showing an interest in this committee. Very important. Very good. We're good? So we'll move on. We moved the next one up, which would be the baseball field licensing agreement. Ron, why don't you lead us off on that, please?
Let me just read the title. This is tab X. It's a resolution of the Village Council of Isla Mirada, Village of Islands, Florida, approving a baseball field licensing agreement with the School Board of Monroe County, Florida, authorizing the village manager to execute the baseball field licensing agreement, providing for implementation, corrections, and an effective date.
Very good. Ron, take it away.
Thank you. If you're following from home or you are in the audience, if you look at our meeting agenda tonight, there's a resolution that I put 2 separate license agreements, to be clear. One is the one that we had on the agenda in December, which was not considered. Since then, we've got more input, and the next one is I put a red line. The red is what's changed from last meeting. So when you vote, I'm asking you to vote on the red line when yes or no. If the red line version passes, we'll obviously make it a regular looking one, but for tonight's purposes and for the public, I thought it'd be easier to compare the 2 by having the red line version. And before we get to it, I want to give a shout out to the Baseball Review Committee that we have had appointed. One of the members is here, Jamie Engel, and I want to particularly say that Jamie has put a lot of hours in, and I wanted to thank Jamie personally for her.
And Tony.
And Tony Hammond's here. And Richard Brown Black. But the review committee did a very good job, had a lot of input. Private citizens like Captain Ed and Sandy also had input. So I think it's a good product. Now, understand that if it passes tonight, it will be different than the school board's. So it's not done. It just
It'll be
means
ours.
It means that they now know our position. We know their position. We still have to negotiate the final product. But I think this is a good step forward to getting us farther down the field.
Well, I would say there's a lot of kudos to go about this. This has been a lot of work and hard work. And I thank Sharon, our vice mayor, for sitting in on a meeting and, really trying to gather everything together. And this red line version, I think my first question to Sharon, to Jamie, and to Tony is, this is the version that everybody is very happy with it. I know Jamie spent a lot of time in on this, and I got to tell you, I'm so appreciative of the work she did on this. It's the public should understand how much she cares about this baseball field and the kids and doing it the right way, and I'm very thankful for her, and I told her that many times today. And I'm going to do it again publicly because it's good work. So, Sharon, take it away, please.
Well, again, we brought both sides together. There was great opposition in the beginning, and we had a wonderful meeting where Richie and Tony and Richard Black and Jamie and myself and Ron and sat down and went back and forth. And the result of this is what is really great for the kids here. And it gives the village control over what we own and a say in every step that's made. And again, we should have a say. This is our property. The kids are so important. We want the best field. We want the best of everything for them. But our position has to be where it's not going to just be done without our say. Every move now will have to go through this council and the public, and that's what we were shooting for. Again, Jamie and I must have talked a million hours on the phone, Richard Black, Tony, I've called him and bugged him, and Richie, and Ron's taken 10 million phone calls for me, and this is a finished product that I am very proud of, and I think this puts the village 20 years down the road where it'll be a great thing for everybody to say that the village, the property, everything is in our control. So thank you to everybody. Big time.
Sharon, thank you. Thank you for your effort. I think your leadership on that was stellar. So,
Thank you.
And I believe even we're probably going to hear from some public, and I think we should. And hopefully we can wrap this thing up, because that's good. So, Marnie, is there anyone signed up to speak on this matter?
Yes, Captain Ed.
For the record, I'm Captain Ed Davidson, Chairman of IRS 501c3 Florida Key Citizens Coalition, and four-year elected member of the school board. I know these folks. The red lines are a tremendous piece of public work. This is what should happen when elected officials listen to the citizens. And it's way better. It was out of control. We were being dictated to by people that pay us $10 a year for access. And we're threatening at various points to lock it up. Couple of, though, issues to bear in mind. I didn't notice this myself until about the third time I read it. Start time to be determined still. Well, the start time has been 2:30 in the afternoon for 24 years. If, for instance, they want to start in the morning and add programs that we haven't even talked about, it'll double the wear and tear. It will pull 36 hours a week during weekdays from our own families. And then there's a comment about weekend use. Well, there was no weekend use specifically for 24 years before this, and that was reserved for families. Big issues, 20-year proposed term with 2 10-year renewals. This is a 40-year lease, but Director LaFear has adamantly refused at public school board meetings to even discuss guaranteed funding mechanisms for replacing the AstroTurf past the typical industry 8-year warranty period, leaving 32 of those 40 years unfunded. That's pretty serious. This lease should last as long as the guaranteed funding. If they're not going to guarantee replacement funding at 8 years, this should be an 8-year lease. It should be as long as the guaranteed useful life of the plastic rug that they're going to put on our ball field. Really serious item, page 11, 6A. Licensees shall comply with all applicable federal, state, county, municipal laws, ordinances, resolutions, governmental rules. That's pretty clear intent. A violation of any such laws, et cetera, shall constitute a material breach of this agreement. A couple lawyers in the room know what that means. How can this possibly not be interpreted to mean exactly what it says? How can this license be signed by the village in light of the multiple, deliberate, persistent instances of lack of public notice of planning meetings not held in accordance with the Florida Sunshine Law during a 4-year period, let's not forget, when there were no licenses in effect? The old ones expired in 2021, and Ron didn't register the new one until 2025. It was a 4-year period with all of the planning. 2 design-build contracts were all underway without consulting with us at all. And the second one was on the consent agenda by the school board. Thank God we've come to where we are now, but you need to remember who we're dealing with and how they deal. During that whole time, Director LaFear's 14 to 16 member Founders Park baseball field design team of public officials, contractor consultants met repeatedly. We're talking about what in the long run with maintenance is going to be a $12 to $14 million project, taxpayers' money. I did a Freedom of Information Act. I got 3 sets of minutes out of 4 years, 3 sets of minutes, and no notice of public access, no public advertisement of the meetings. This is deliberate and overt, and Mr. Attorneys, this darkness needs a substantial, do it over again in the sunlight cure. We can have a planning charrette. There's lots of ways to deal with this, but this is some pretty serious stuff. And here's a real glitch. Page 17, number 15. This agreement sets forth the entire agreement between licensor and licensee in respect to the subject matter. It supersedes all prior and contemporaneous negotiations, understandings, agreements, written or oral, and the parties. No, it actually doesn't. This is a subpart of the interlocal agreement. It does not override the interlocal agreement, and I believe our attorney has acknowledged that issue previously. But it cannot be allowed
Thank you.
to erase all of their promises that they made.
Thank you, Ed. Marnie?
Yes, next up, we have Mr. Wishmeyer. He is on Zoom, so give me just 1 second. Okay, Mr. Wishmeyer, go ahead.
Thank you. I hope you all can hear me. I tried to get in on public comment, but I'm stuck in traffic trying to get home for the game. I certainly want to express my appreciation for all the time and effort that has been put into working out this agreement. I know in December, I was under the impression that there was a strict deadline. If we didn't do something by that December meeting, that they were going to pull out. Obviously, that didn't happen. So I'm just hoping that we can all stay on good terms and make sure that we stick to our guns and stick to the agreement that you all had worked out. Thank you.
Thank you, Jim. Marnie?
There's no one else.
Mr. Chair?
I want to say something. I appreciate all Captain Zed's points, but a lot of the stuff you brought up is in the past. This new agreement takes away the past, and we only can move forward. We can't go back in time. And yeah, a lot of things were done wrong that we all found out. But I say we should focus on the agreement gives us control. We only can start from now, and we can just prevent things like this from happening again. So I think this is fair, and I think it's good. I appreciate, like Tony has told me, there are games on Saturdays. They always have been. And so there's a lot of things that have changed with the times. There's a lot of things that happened that weren't right, but we can now change this.
Yeah.
Everything that is done, like the building that they're going to build or renovating the other one, we have a say in it. There will be public workshops, and everybody can give their input. So this is a new beginning, and we can't look back. We can just move forward. So that's all I want to say.
Thank you, Sharon. Thank you. Marnie, are there other public speakers?
No, sir.
Okay. Hearing no more speakers, do I have a motion?
I'll make a motion to approve.
Do I have a second?
Second.
All right, Marnie, I'd like to call the vote on this.
Vice Mayor Sharon Mahoney?
Yes.
Councilmember Anna Richards?
Yes.
Councilmember Steve Friedman?
Play ball, yes.
Councilmember Deb Gillis.
Yes.
And Mayor Don Horton.
Absolutely.
Motion
Yes.
passes 5-0.
Thank you, thank you, thank you. A lot of work. Thank you, guys.
I seriously, thank you. This is probably the most public input on anything I can ever remember. And so not everybody's going to be happy, but I think as a whole, this is a great document, and I'm thankful for all the hard work that happened in this. So let's move on to ordinances. Let's see, Jennifer, would you like, well, John, you're going to read the ordinance in?
Yep, and they're companions, so I can read them both together. These are ordinances that are on second reading. Tab B is an ordinance of Isla Marta Village of Islands, Florida, amending policy 3-2.1.2, specific standards and requirements for workforce affordable housing, providing for the transmittal of this ordinance to the State Department of Commerce, providing for severability, and providing for an effective date upon approval of this ordinance by the State Department of Commerce. And then the companion, when tab C, is an ordinance of Isla Marta Village of Islands, Florida, amending Village Code sections 30-476, building permit allocation, evaluation, criteria, and award, providing for the transmittal of this ordinance to the State Department of Commerce, providing for severability, and providing for an effective date upon approval of this ordinance by the State Department of Commerce.
Thank you,
Good
John.
evening, Council. Thank you. This may feel like deja vu. We were just here in November and approved these on second reading unanimously. Due to some administrative faults in the department, we rendered these past the 10-day deadline to Commerce, so they were rejected by Commerce. Once they're rejected, we have to rehear them on second reading. So this is simply a rehearing for another vote, so we can re-render them within the 10-day timeline, which we will do tomorrow, so we don't miss it again. And so that's simply all this is. Nothing has changed. There's no new information. It's just hopefully a simple revote.
So if it passes, I can sign them tonight, and you can zip them right up there, right?
Yes, sir. I have the documents with me.
Atta girl. Okay. Is there any public comment on this, Marnie?
No, sir.
Do I have a motion?
And we'll take the motion, the vote separately, so.
We'll take item B first. Is there a motion to approve item B under ordinances?
Motion to approve.
I'll second.
There's a motion and second. Marnie, will you call the roll?
Councilmember Anna Richards?
Yes.
Councilmember Deb Gillis?
Yes.
Councilmember Steve Friedman?
Yes.
Vice Mayor Sharon Mahoney?
Yes.
And Mayor Don Horton?
Yes.
That motion passes 5-0.
All right, is there a motion on tab C or item?
I'll make a motion on tab C to approve.
Is there a second?
Second.
Marnie, will you please call the roll?
Councilmember Deb Gillis?
Yes.
Councilmember Anna Richards?
Yes.
Councilmember Steve Friedman?
Yes.
Vice Mayor Sharon Mahoney?
Yes.
And Mayor Don Horton?
Yes.
That motion passes 5-0.
Thank you.
Moving on. John?
Yep, we're in the quasi-judicial section, so please be advised that the following agenda items are quasi-judicial in nature. If you wish to comment upon these items, please inform the village clerk by filling out the available sign-up form. An opportunity for persons to speak on each item will be made available after the applicant and staff have made their presentations on each item. As a reminder, testimony in quasi-judicial items must be in person. Zoom testimony is not permitted. These proceedings will be handled in accordance with the village code requirements. All testimony, including public testimony and evidence, will be made under oath or affirmation. Additionally, each person who gives testimony may be subject to cross-examination. If you do not wish to be either cross-examined or sworn, your testimony shall be disregarded. The general public will not be permitted to cross-examine witnesses, but the public may request the council to ask questions of staff or witnesses on their behalf. The full agenda packet on each item is hereby entered into the record, along with the village code and comprehensive plan. Any correspondence that was received by the village staff is included in the file and part of the record. Persons representing organizations must present evidence of their authority to speak on the organization. Further details on the quasi-judicial procedures in section 30-256 of the village code may be obtained from the clerk. Tonight there are two quasi-judicial items. They're tabs D and E. At this time, I'd like to ask anyone who intends to speak on the quasi-judicial items, either D or E, please raise your hand to be sworn in by the clerk if you intend to speak.
In the matter in which you are about to give testimony, do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth? Yes. The witnesses have been sworn.
Mr. Mayor, tab D is stated as follows. It's a resolution of the Village Council of Isla Mirada, Village of Highlands, Florida, considering administrative appeal of the environmental determination by the village's biologist filed by Barton W. Smith, agent for Bonefish Holdings LLC, appellant, for property located on Old Highway having real estate number 00404520-0000000, 00404260-0000000. This is going to be a little bit. 00404-270-0000000, 00404-280-0000000, 00404-290-0000000, 0009-5045-000300, 0009-5045-000100, and 0009-5045-000201 on Upper Matacumbe Key as legally described herein, providing for the transmittal of this resolution to the State Department of Commerce and providing for an effective date on the approval of this resolution from the State Department of Commerce. That
I'm
was a
sorry,
mouthful.
John. I'm sorry, John, I missed the third one.
Yeah, exactly, right?
We'll also need this
I was
ex
going to say, maybe
parte.
we'd give them a bonus point if they would just unify into one real estate number.
Do you need
Yep.
disclosures?
I do, that's what I was getting to. So, council, if you begin, if you'll please disclose any ex parte communications you may have had. This is tab D, and if you remember, please state not only the person, but also the substance of the conversation that, to the best you recall.
Anna?
I don't think I've spoken to anybody besides staff.
Sharon?
This was on the last council. So I spoke to people last 2 years ago, a year ago, whenever this came up, but nothing recently, so.
Steve?
Just staff.
Deb?
Just staff.
I've spoken to staff. I will disclose that prior to Hurricane Irma, many years before Hurricane Irma, I actually consulted for the owner back then on his piece of property in my private business. But I don't even know if he's still the owner, and I haven't spoken to him since Hurricane since Hurricane Irma.
And your work is concluded, you have no other...
100%, yes, sir.
Okay, and years ago, this,
Yes, I
if we have to go back that far, I
Well-
was sitting on council when it wasn't this subject, but the other subjects concerning this property was in front of council. But
Okay.
that's been concluded a
Okay,
lot
but
of
yeah,
years
but
ago.
didn't involve this.
No.
Very good.
Yes, we are good.
All right.
Let's see, so staff will take the lead. Daniel?
Good evening, Mayor and Council. I am Daniel Parabach. I am the Senior Environmental Planner and Village Biologist. Before I begin, I'm probably going to reference the Kiewit Manual, so I'd like that entered into the record. And I also printed off copies of my presentation in case you want a hard copy. All right. I'll read the description, but I will forego reading all the parcel IDs.
Excuse me, Bart, hang on a second. We got a presentation here. Do y'all have a problem over there? Okay, thank you.
I'll bring it up. He hasn't seen this.
I have an extra copy for you.
Just for the record, we have not received the presentation until this time. The applicant is required to provide a presentation in advance of the hearing, although now we have received it, so we just want to make sure that's noted.
The code does not require that we provide a presentation in advance, but it does require that the applicant provide their information in advance, 48 hours in advance.
Okay. John, we're still good, right?
Yes.
Okay, Daniel, proceed, please.
All right. So I'll read the description, but I won't read all the parcel IDs unless John wants to do it for me. The subject property is located on Upper Matacumbe Key with real estate numbers as stated in the title. The property is within the native residential zoning district. The agent, Smith Hawk Attorney at Law, has requested administrative appeal on behalf of the appellant, Bonefish Holdings LLC. The request was to permit fill in the portion of the wetland and allow the development of a single-family dwelling unit and associated facilities, or provide sufficient financial relief to the appellant based on the complete deprivation of any economic or productive use of the property. So in other words, the applicant is appealing the village's determination that no fill is permitted within the wetland on the property. So here we go. See if I can do this right. Everybody has the same problem with this remote. All right, the property, this is just the location. It's on the ocean side of Upper Matacumbe Key. It is just south of the Shell Shack on the old highway. A little bit of history on the property. In fall of 2017, as you all know, Hurricane Irma, the property was cleared and disturbed without permits. This was confirmed by the Army Corps, South Florida Water Management District, and the village. On October 2017, Army Corps issued a cease and desist on the property, and the Water Management District and the village issued notice of violations for the wetland violations and illegal clearing. In 2018-2019, a consent order was issued to settle the state and federal violations. As a part of that order, wetland restoration and a conservation easement were required. For the village, a special magistrate issued an order for the beach berm and hammock to be restored, and that happened in early 2020. So from 2019 until the semi-recent present, the three-part restoration occurred, and that included restoration of the wetland, the beach berm, and the hammock. The restoration included debris removal, regrading, replanting of native vegetation, and maintaining the property invasive exotic vegetation free for 2 years. This is what the property was mapped as in 2015. But prior to the illegal clearing and disturbance, I have a code expert there that just reminds everyone that these maps are a starting point and that all habitats must be field verified. Also that the code does not recognize unlawful conditions when considering development. And so this map represents what has been field verified the site to be today. I'm happy to report that all the habitats have been successfully restored back to undisturbed conditions, and no portion of the property can be considered disturbed anymore. So it has gone a full restoration, and it went well. So KEWEP, the word you're going to hear 100 times tonight. So KEWEP stands for the Florida Keys Wetland Evaluation Procedure. It's specifically designed for evaluating wetlands in the Key. It was specifically designed for just Monroe County. In simple terms, it's a basic scale of 1 to 10-ish, low being 1 being the lowest function, 10 being the highest function. This process is not subjective, it's objective, it's scientific based, and it's a fairly simple process. The manual walks you through it. If X, Y, Z, then 1, 2, 3, etc. A little bit on the timeline and the timing. So in December of 2022, New Leaf Environmental submitted a wetland report for this property. The report lists 2 wetlands, both red flag wetlands, meaning no development. And if they're red flag wetlands, that means no KEWEP score can be assigned because it's automatically undevelopable. In July of 24, pre-app was held to determine the amount of development possible on the property. Staff informed the applicant, based on their submitted report from 22, that no development in the wetland was allowed. The pre-app was withdrawn by the applicant after the in-person meeting, which prevented that determination to be in writing. So the next month, in August, the owner hired a second biologist, Dr. Phil Frank, to determine the correct wetland classification and on-site assessment with village staff. Dr. Frank and staff agreed that there's no freshwater wetland, that indeed is a salt marsh wetland, and the correct wetland score, KEWEP score, is 7.5. In November of that same year, New Leaf Environmental provided a new KEWEP reporting that it is not a freshwater wetland, and the score should be 4.85. In April of 25, we had a new pre-app meeting, and staff stated that based on the prior assessment with Dr. Frank and village staff, that the New Leaf Environmental score of 4.85 is not accepted. That village determination is now being appealed tonight. All right. So before we go on, the KEWEP process and manual were written by the EPA in conjunction with state agencies and Monroe County. They do offer periodic training, and it's offered, this past time, it was taught by the gentleman who developed the actual manual, which was kind of a special treat to attend, and I attended that. It was in May of 2024. The training was 3 days and included biologists from all the municipalities, the county, and then almost all of the private biologists that do Key Web scoring. So it was a nice group of people. You had public and private biologists there. It was a really good training. The training is 3 days, and we score 20 sites altogether, and they go from Key West all the way to North Key Largo. I was in attendance for all 3 days. Unfortunately, Mr. McCoy could only make it on the first day, which was kind of a shame because on the third day, at the end, we had a debriefing with the gentleman from the EPA, and he says they do it periodically, A, to give updates to all the biologists on the methodologies that are to be used in this process, but B, it's to get all the biologists who work on this stuff, both public and private, together to come to consensus on how wetlands should be scored in the county. And we took out all our sheets and we compared them from day 1 to day 3. And day 1, we were all over the map. Day 2, we're getting better. And by day 3, we were only tenths of a point away from each other. Like we had 20 people that were almost dialed in on the exact same score, which was really cool. Moving on, the Key Web scores for this property. I've been involved since early 2018. I've spent over 30 hours on the site. I sometimes, oops, wrong way. One day we'll figure this out. Anyway, sometimes I feel like I spent more hours on the site than any human being. I saw it from the restoration all the way till today. And that doesn't include the 6-hour process I spent with Dr. Frank doing the Key Web analysis. And that analysis yielded the correct score of 7.5. And that score was corroborated by Dr. Frank during the analysis when we did that field assignment. I'd like to point out that Dr. Frank is also a village qualified biologist, and he was one of the original biologists who did all the Key Web scoring when it first came out in the 90s. So New Leaf Environmental claims that the score should be 4.85. And comparing the two sheets, if you see, oops, I still went too far. Why is it going backward, Frank? I clicked the same button. It's going the wrong way. Go one more. There you go. All right. So in comparing the two sheets, a lot of the categories had the same score. So we agree on a lot of the scoring for several of the categories. But now it'll go to the right one, hopefully. I found some errors in the scoring when I reviewed it. The New Leaf score sheet. There. You're going to have to do it for me. Thanks, Frank. For example, the number of habitat types under the Key Web, the habitats, all the habitats on and adjacent to the site have to be counted, and there are 5 different sites that are on and adjacent to this wetland. You have mangrove, salt marsh, buttonwood, beach berm, and hammock. The New Leaf score sheet only counted the adjacent habitats, and it only counted 1/2 of those. So this one discrepancy almost accounts for a full point. So if we were just to correct this one section, it would make the score 5.75, which would make it not developable. And that's just one of the errors I found. So then we can go, Frank, if you could do it for me, that'd be awesome. So what does that mean for the property? Correctly scoring this wetland does not prevent development on the property. There are uplands on the property that can be developed. If the hammock is determined to be moderate quality, not yet. Over 10,000 square foot could be cleared, and if it's high quality, about 3,400 square foot of the hammock could be cleared. Also, this property is assigned TRE number 6, so they do have an existing building right, and what that means is that if they came in for a permit tomorrow, within that allowable clearing, we would be able to approve that permit for the property. Let's see. Okay, next slide, please, Frank. All right. So in conclusion, the property is a wetland restoration success story. It took almost a decade of hard work to improve and restore both the wetland and uplands. All habitats have successfully been restored to undisturbed conditions. Next slide, Frank, if you don't mind. The high-functioning wetland, when evaluated correctly through Key Web, receives a 7.5 as corroborated by the third-party biologist, Dr. Phil Frank. As the score is based on an objective scientific process, which the village has followed correctly, and based on the most recent full 3-day Key Web training course. After reviewing the most recent New Leaf environmental score sheet, several mistakes were found, and the score cannot be correct. Correctly scoring this wetland does not prevent development on this property or remove the building.
Thank you very much, Daniel.
Last question.
Is there any questions?
Daniel, you were here the last time this came up in front of us, and correct me if I'm remembering this correct, that I want to say that the property was appraised for, and I'm just making up this number, let's just say 3.9 million, and Florida Forever was going to buy it with us in the village, but they wanted 2 million more, and it was up to the village to bring in the 2 million. Is this correct? Am I remembering this right?
I wasn't involved with any of that. I think that
Oh.
was Pete here. Yeah, Pete could speak.
Is
to
that right? Am I right, Pete? Sort of. Okay, well, I knew it was something, so, I mean, excuse me? Yes, I do, because,
I think we need to get you on the record, Pete.
Yeah,
Since
he
this
was
is
sworn in.
quasi judicial, you should,
He was sworn in.
okay.
yeah, because.
No, I just mean on the microphone.
I
Sure.
remember something about we were trying to buy it. Am I correct?
That's correct.
Okay, go ahead.
So,
please.
in fact, the council at the time did discuss this and
Yes.
came up with a value, and an offer was made.
Yes.
So that was done in conjunction with the Monroe County Land Authority acting as our agent under the interlocal agreement we have with them. So an offer was made of $4.84 million to the owners. The property was appraised at $3.59 million. So the difference, that difference was made up by the council. The council had agreed to make that difference up.
Yes, so I'm not crazy.
The offer was rejected by the owner, no counteroffer made. That was it.
Okay, so I'm not crazy, that I am right, that this came in front of us.
Absolutely.
And that it was up for sale, and we had
Yes,
looked at. Okay.
still for sale.
Okay, thank you.
Sure.
Can I just, while Peter's up here, Mr. Mayor, can I just clarify? It's my understanding that the village is not actively seeking to acquire this property at this time. Once it was rejected, we moved on.
Correct.
Correct.
Thank you, Peter.
All right, thank you, Peter. All right, is there any other questions of Daniel at this moment? Do I ask Bart to give his presentation now? Okay, Bart, your turn. You're up. Let's do it.
Good evening. Good to see you all tonight. Happy New Year. Bart Smith on behalf of Bonefish Holdings. I also have a presentation, and I've learned from the prior presentation that I am not going to use the clicker. I am going to ask you to go forward and backwards. And so just when I say go forward one, just go forward one, and we'll try to not be jumping around.
That works.
So there are certain things we can definitely go through quicker because we're working off the same property. If you can go forward a slide. All right, this is the property's information that was discussed. I also won't go through that many zeros. It's approximately 7.43 acres. What's very important to note, though, is that Flume is residential conservation, native, and its land use district is native residential. Next slide. This is an aerial depiction of the property as it looks today. As you can see, real quick, to the north and to the south are developed properties. Next slide. This is the flood maps. It shows that most of the property is actually in a flood zone. Next slide. So why it's interesting that I bring up the point about the current zoning is it actually, when it was purchased, it was not zoned that. It was actually zoned improved subdivision, and it was also zoned suburban residential, which had a much higher density. It was 1 unit per lot, and it was also, for the suburban residential, it's 0.5 allocated per acre. And that was part of the county zoning maps, and it was purchased under this zoning category with expectation that it would be developed under that zoning category. Of course, the village incorporated in 1997. They started changing zoning maps in 2001, and it ultimately led to it being downzoned to the native residential zoning. Next slide. I think I just went through that. Next slide. So, my client has owned this property for quite some time. A lot of you are aware of that. He's tried in many iterations to develop this property. He's come through with, So he's gone through a lot of different iterations attempting to develop this, as many of you are aware. It's been a long labor of love to try to find some way to develop this property. It's been, since acquired, it's been downzoned. We've had the matters of trying to get development rights, and we've ultimately had to work on getting permits through the state agencies. All of this is part of the file and has been part of the files for years. There's been a significant amount of attempts to provide for a benefit. It's a reasonable economic use of this property. And at this juncture, it's down to a single-family home, attempting to develop that on the property. And so if we can move to the next slide. So as you're aware, Hurricane Irma hit. The property had code cases. They're actually brought forth first by the state, it was South Florida Water Management District. The property was required to be replanted to the satisfaction of South Florida Water Management District. It went through multiple inspections. The permits were closed. And then the applicant then went back to South Florida Water Management District and applied for a permit to fill a portion of the property. And so it went through South Florida Water Management District first to get an application to fill. Next slide. Next slide. So these are more aerials just showing what happened with the post-Irma to where it is now. And in 2024, the applicant applied for a fill permit from the South Florida Water Management District. Next slide. So ultimately, after satisfying all the conditions of South Florida Water Management District, which is the state agency that governs and oversees wetlands, disturbed wetlands, the state agency has issued a fill permit. It has issued a permit for the area that we have applied for, the area we intend meets the criteria to be filled. The state agency utilizes the same criteria as the local governments to determine whether a wetland is permitted to be filled. The state agency that required the property be restored, after it was restored, has now approved and permitted a fill permit for what is being requested in this application and for what we are deeming a property that's Key Web score allows for the filling of this area. Next. Oh, and by the way, the area at issue, it's on this slide too. You can go forward. Is 0.86 acres. So let's be clear. This is a 7.3 acre property. Been approved for 0.86 acres to be filled. Now, the rest of it would then go under a conservation easement. So ultimately, 6.5 acres are preserved. 0.86 acres are allowed to be filled. The state agency has authorized this, and so we have applied to the village for the same fill, and ultimately it has been determined by the village biologist that he disagrees with our analysis of the KeyWep, and so that's why we are here today. To go even further, it specifically provides for the construction of a single-family residence with associated facilities and stormwater runoff directed to the swales. Next slide. Oh, wow, nice catch. So the permit itself, beyond that, required payments into the mitigation bank, which have been done. It provides for buffers from the areas that will be preserved. It specifically goes into the delineation of the different areas, including the areas that are suitable to be filled. And it states that no work is to be proposed within wetlands under the conservation easement, and that that the permit itself has been mitigated to the state's satisfaction. By the way, that mitigation has been paid. Next slide. This is the permit that's been approved. It identifies the areas that will be utilized for the single-family home. the areas that will be subject to a conservation easement, and it identifies the wetland areas that will remain, including identifies the areas that will be permitted to be filled under the state permit, which, by the way, the state agencies follow the same guidelines, same requirements that the local governments are. So we are not sitting here saying we're the only one that believes that this qualifies to be filled. The state's already approved it. It's permitted it to be filled. So there was some history on the Key Web scores. I was not involved in creating the Key Web score, and rather than go into the technical aspect of it, I'm going to bring Mr. Mike McCoy up here to explain his analysis of the Key Web score and address some of the statements made by Daniel. And Mike, if you forget anything, I'll cue you. And at this point, I'll turn it over to him. And if you do have questions for him, feel free to stop him. Thank you.
Thank you, Bart. Thanks, Bart.
And after he's done, I'll have some final conclusion comments and remarks. Thank you.
No doubt. Thank you.
Thank you again. This is Michael McCoy from New Leaf Environmental. And despite Daniel and I taking a few jabs at each other tonight, we go way back, and we're colleagues. So it's all in a good professional spirit. So I did the Key Whip scoring for the site.
Next slide.
Yes. Quick bit of background. So over 20 years of experience as an environmental consultant, most of them in South Florida. Daniel's correct about attending the Key Whip training. That's actually my second full Key Whip training that I attended, 2 out of the 3 days, but maybe I dodged Daniel during the second day. And Mike Roberts, who I'm again go way back with, actually looked at me for the third day and said, "It's the lower keys. Don't you do almost all of your work up here?" He's like, "Come on, buddy, that's just, you don't need to attend the last one," which is actually what motivated me to do work that pays the bills on the third day. And I will note that on the first 2 days, 2 of those sites are ones that I'd actually scored myself and worked with the county on those. And in that same spirit, and noting that despite what some of the scoring differences between me and the village biologists were called errors, if you know anything about this wonderful Key Whip system, which is, if you read the manual for it that Daniel brought, holy mackerel, it's a lot to absorb. So there can be differences between two competent biologists and what they would think. So as part of the effort in my scoring and what I previously submitted, I did an Information Act request, first from the village, on Key Web scores submitted for this property and for any similar properties for the last 5 years. And I was told that there are none that the village has that are approved Key Web scores. So then I did a similar Information Act request to the county and received a number of sites, and I chose nearly all of them. 2 of them that they sent me didn't actually match, but I had 6. And so I did an analysis where I actually used those to make sure that my scoring is in line with the other approved, in this case, county scoring that's going on. And then after receiving the village's score, which I think just for a point of clarification, I've worked with, again, Dr. Frank for years, and we asked him after the village had told us that there was this other score that he prepared. He said he didn't. He had a meeting, but he never prepared a score for the site. Because, again, I wanted to incorporate anything that anybody else had done. So in my own analysis, there are 5 discrepancies between the score that I provided and the village biologist score. I don't know how long I have if I want to go over each of those. Okay, so it's roughness score, habitat type, wetland dependent species, threatened and endangered use, foraging score, and disturbance regime score, which are categories. It's kind of hard to read up on the screen, but those are the different categories. So for the first one, the roughness score, my score was 0.5. The village's score was 1.0. However, when you look at the guidance for this, yes.
Just for clarification.
Yes. And if anybody needs time to go through the manual, look at something that I'm referencing, please let me know. But I want to try to keep most people awake through going through scoring, so I'm going to try to keep a good pace going. So just throw up a hand if you're like, I don't know where you are. So on that roughness scoring, with the class of Buttonwood Marsh, I scored it as a 0.5, but the village scored it as a 1. I cross-referenced that with all of the sites that I was given by the county, which are similarly completely vacant and fully vegetated sites.
Next slide. Okay, these are the memo that you have with the different properties?
Correct.
Okay, keep going.
Thank you. So each of these properties are like this one, fully vegetated with native vegetation, wetlands on them, and completely undeveloped. So out of the 6 that I used in there, all of them had the score that I provided or lower. And again, so these are all going to be Buttonwood Salt Marsh wetlands or mangrove wetlands, which are the same or rougher density. So in that, I'm just showing that the score that I gave is more in line with industry standard than what the village provided.
And just for clarification, so all these other scores were accepted by the county biologist as proper QUEP scores?
Correct, and that's what I provided in that document. You can see these are all past approved, county-approved QUEP schools.
And these are all on the record? Correct.
Second is the habitat cover types. So the village lists 5 cover types. I know that's one thing that Daniel brought up.
Last slide.
Thank you. However, the groups that are listed in large part, where he mentions the 5 habitat types, are kind of splitting hairs and saying, well, we have mangrove area. Well, we really have a high and a low. Or we have this area. We have we can split it into several subcategories. However, that is not what is typically done. And instead, the QUEP manual itself, switch back and forth here, has a statement with the classes. This is on page 20 of the QUEP manual, which specifically talks about these habitat groups, lists mangrove forest under intertidal, and then under supertidal, open salt marsh, and buttonwood salt marsh. Those are 3 separate habitat categories that are listed by the village biologist. However, the county QUEP manual does say may have to combine the above class with the following classes into one signature. So again, once you do that and you follow the manual, you'll see that the splitting of it isn't warranted, and the manual actually gives guidance to show that these should all be part of one. For the next one, threatened and endangered. Actually, there was one that did not make it into the memo, so I'll just, but it is up on the sheet, which is wetland dependent species use, which if you look on the scoring sheet, that's wetland dependent use diversity. And on there, new leaf score is a 0.1, with the village having a score of 0.5. However, there's, with all of the wetland-dependent species listed in, by the village biologist, has a number of different kinds of birds, but the QUEP manual calls bird use as one, not each separate species of bird. And for their second and third species is listed raccoons and opossums, which are pretty ubiquitous throughout the Keys and are not considered wetland dependent, in that neither of them absolutely need wetland habitat to complete their life cycle. And in the 6 reference sites that I obtained and provided, not a single one lists either raccoons or opossums as a wetland dependent species, but being in the Upper Keys would all, of course, have those.
To be clear, though, the village biologist added to the score because of possums and raccoons?
That's the difference between his score and mine, correct. The next one that you'll see on my memo, threatened and endangered use, foraging, and resting score, where the New Leaf score is a 0.1, the village score is a 0.5. For that, the biggest difference is that the village score listed 2 potential threatened endangered species that could use the site, piping plovers and peregrine falcons. However, the peregrine falcon has been delisted and is no longer a threatened or an endangered species. And so that's why that score is most correctly at a 0.1 for one species as opposed to 0.5. And that's a federal listing. The last one is the disturbance regime score, with New Leaf providing a score of 0.3 and the village providing a score of 0.7. Where the main difference here is the KeyWeb guidance says that what you're supposed to look at is adjacent development, and if there is any adjacent development, then that's what downgrades it. And so the scoring styles are if it is completely surrounded by intense development, that gets it a 0. If it is completely surrounded by protected wilderness, that would be a 1. And so the score that was chosen by the village biologist is a 0.7, which is close to development but buffered from it. However, especially considering where on the property the proposed development is, it actually has abutting land use that's fairly intensive. It has Old Road covering one side of the entire property, and then on both of the opposite sides are previously developed residential lots. And so with that being the assessment area, that actually gets it a score of 0.3 for having adjacent development. Again, not only looked at the KeyWeb manual, but I looked at all 6 of the reference sites that the county provided. And in those, 0.3 was the highest score given to the similar circumstance. And all 6 of the ones I provided are currently undeveloped sites with both wetlands and uplands, which have single-family residential homes on either side and a public road bordering one side. So it's a really, really solid match. We're not, saying, well, these things aren't exactly. It's a pretty much exact match. So again, that's a difference there in the scoring. So with that said, I think that's my explanation for.
So based on your training experience and professional expertise, do you stand by your KeyWeb score of a 4.85?
Yes, I do.
I have a question for Mr.
Yeah,
McCormick.
yeah, before I have him sit down, if you have questions for him, I'd prefer you do it now before I wrap it up.
I was just saying, and after you guys are done with your questions, I'm not sure, staff has the ability to cross-examine too.
I'm sure,
so,
yeah. Mike, how many KeyWeb scores have you done in your career?
Several dozen at least. I couldn't.
And they range from the lower keys, the upper keys, or middle keys?
Exactly. All
Okay.
throughout the keys, exactly. And in addition to just KeyWeb scores, of course, for wetland permitting, as a former wetland permit reviewer myself, I've conducted, UMAM, water, and other assessment methodologies that go throughout this state and some others.
Historically, how long have you been in business?
As New Leaf Environmental since 2017.
Okay, thank you.
Sure.
Anybody else have any question for anyone up there right now?
Not at this time.
Not this time, okay. Very good, thank you. Bart, carry on.
Thank you. All right, next, put the slideshow up again. So that gets us where we are today. So we submitted our KeyWeb, it was rejected. We were provided a QUEP score that was 7.5. We requested, because we disagreed with it, that it be placed in writing. We've appealed that to you today. And at this juncture, it is our request that you overturn the denial of the applicant's QUEP score. That's what we're here for. We've submitted the QUEP score as we're required to. It was rejected or denied. We've appealed that. We believe Mr. McCoy has provided evidence that his score is accurate. Not only is it accurate, he's gone above and beyond what you normally do. Normally, you're just scoring the property according to the manual. Because of the importance of this, he not only scored the property, he reconciled that score with other similar properties throughout the county to confirm that all his scores are in line with those for any of the areas that are even in question. And all of them mirrored his score. I do believe that he's provided the most accurate QUEP score. It allows for the filling of the property. It is consistent with the South Florida Water Management District's determination that this area can be filled. Next slide, please. And so with that, keep going. Next slide. Next slide. Next slide. Next slide. And I would remind everyone that even your maps identify this area as disturbed with hammock and disturbed area that we're requesting to fill. All of this is consistent with our position. Next slide. Next slide. So with that, we would request that based on the evidence provided, the state permit, that we have a BPAS unit attached, and that the scoring that has been done by Mike McCoy, we request that you overturn the rejection of the QUEP and approve the QUEP. I would be remiss to not bring up Shands because it's been brought up. Shands is the law, and we disagree. This is, if we cannot get this approved, there is no utilization of this property. This property is 7.6 acres. This property, we're requesting the minimum development possible, which is a single-family home. My client has tried to work on this property, developed it for 24 years. The zoning's been downzoned. Its rights have been taken away. It's asking for the minimum possible, which has been approved by the state. I'll remind everyone, a property was just bought in Islamorada for $27 million. That was an acre. Let's not create a liability. Let's allow the development of single-family home and then conserve the remaining 6.5 acres. It's a reasonable resolution of this case. It's based on a very factually driven QUEP score. And so with that, I will hope that you overturn the decision to reject the QUEP score and allow us to proceed. Thank you.
Thank you, Bart. Jennifer? Does staff have a rebuttal or another?
I think Daniel might want to cross-examine the witness.
Come on up, Daniel.
You need me or him?
Him. I'll keep it short. We're 30 minutes from kickoff. I would like to point out just a couple things. The local governments and state agencies do have different criteria for permitting. Just because you get a permit from South Florida Water Management does not mean that approved permit criteria is the same for the local governments. We actually have an open code case right now for a similar case where a wetland was approved to be filled by DEP and was filled by the owner, but he didn't get permits from the village. And now he's in trouble with the village because we did not approve the fill. So if you're going to develop in Islamorada, you need approval from the village of Islamorada to do so. So just because they have approval from the state does not necessarily mean that that development is approvable by us. And in terms of the QUEP, I won't get down super into the weeds with this, but I will point out that on the roughness scale, if there's woody vegetation, buttonwoods, mangrove, you go all the way to the top of that scale. So you can't really split hairs there. The manual's pretty clear. And then Frank, can you do me a favor back there? Can you grab my presentation and go back to that Habitat 2024 map? Thanks. In terms of the possums and raccoons, I just kind of put that in there as an example. If you only need 3 different animals that are wetland dependent. In the wet season, when I was working there, it's like 3 feet deep. I saw frogs. Actually, it was really cool. I don't know if it's escaped pet, but I did see a freshwater turtle, and I'm on the record, I did see that. So right there, that automatically brings that category to 1. So, working on that for me, Frank. Thank you.
While Frank's doing that, I got a couple of questions
Sure.
for you, if I can. Through both of these reports, or through your report, I kept seeing you refer to a red flag wetland, which is, I guess, a high score in the Key West, something that automatically stops development when it's deemed a red flag wetland.
Right. If it's red flag, it doesn't receive a score at all.
Okay. And Mr. McCoy also said that he had requested from the village any key webs that the village has done, and the village didn't produce any. Didn't you do one next to SD Marine or the old Smuggler's Cove quite some time back?
Harry and I, we did key webs together.
That'd be Harry DeLashman?
Yeah, Harry
Okay.
DeLashman. But
Okay.
none of those key webs were a part of any submittal to the village, so we have no record of those.
Okay. You're still moving on? Okay.
Yep, he's got it here. Just, I don't want to harp on this point, but it could be professional interpretation in the manual. Can you go back to that 2024 map, please? We can do it. And I'd also like to point out, as another fact too, is I wasn't the only one on the site that day doing this key web. Phil Frank was there. We spent 6 hours on the site. We spent 2 hours back in the office. It was a full day. We sat down after the site assessment and scored it together. He did not provide his client a written score because that's not what he was paid to do for that job. But he and I am on the record. He was with me and we went through the process together. We both ranked it exactly the same, 7.5. There we go. All right, Mike, time for me to be a bad guy. All right, so the assessment area, which is basically that blue outline, so that's the wetland area. The manual says you have to look at habitats in that blue area and everything touching it. So just this simple map, not picking hairs and calling different habitats, just the basic habitats. You have mangroves touching it, you have beach berm touching it, and you have hammock touching it. So that is 4. Do you disagree with that, Mr. McCoy? And I'll remind you that if it is 4, that score is 1, and no matter any other differences, that would make it not developable.
Right. Well, we just have a different way of interpreting the Key Whip manual. And again, that is because, and do you lump together and you say, well, I'm going to call this area upland, native, beach berm, and then over here, I'm going to say this more upland, native, hammock. And I'm going to say this area is a wetland outside of my assessment area, which is a mangrove, versus this mangrove wetland is part of my assessment area. So that's why I obtained the sites from the county to see how they were scoring. And they have a very similar matrix where they have a wetland surrounded by upland areas, and they scored it all the same way that I did, which is why I got those.
Just one last point I'll make is each site is different. Comparisons with other key webs done by other biologists are helpful, but they're not conclusive. And also, I would state that this site is kind of a rarity as it was fully disturbed and then restored. So therefore, I don't think any of the other county sites received a full restoration. Anyway, that was all I had. And then if you have any questions, I'm happy to answer.
Are there any questions of Daniel? Daniel, does the state the South Florida Water Management District utilize the Key Web scoring when they do any reviews?
The Key Web is designed specifically for the county.
It's done just in the county?
For the county.
So the state doesn't even pay attention to that?
They can
whatsoever?
issue permits regardless of Key Web scoring.
Okay.
Mr. Mayor, can I?
Deb?
Go ahead.
I'm sorry.
No, go ahead. I'll defer to council.
No, whatever. During both presentations, You said that development was possible in certain areas, and part of it would depend on the quality of hammock as to how much you could clear, and I understand that completely. In your presentation, you said that no development was possible. Oh, sorry, I'm pointing to the wrong guy. Those are exact opposite statements. Comments?
Well, there is a TRE on here, too.
Yeah, and there's a TRE on here.
There's a TRE, but you have to be able to actually have a developable area that is capable of actually developing a home, and it has to be a reasonable home. And so the reality is,
Reasonable home.
well, even 1,500 square feet, you can't develop with the habitat and setbacks and everything else on it. So, no, you cannot develop this property unless you fill a portion of it.
Daniel, you had testified that there was a developable area on the property.
There is sufficient area with setbacks, and I believe without any variances either, that you could build a single-family home in the upland without filling wetland.
Okay. Sharon?
Are you talking
reasonable one.
about the property, like would be on US 1?
It would be close to US 1,
Okay, so
outside of the
it's
wetland.
not on the water then?
No.
Okay.
Okay.
Yeah, I get it. I just want to make sure.
I believe the widest part would be the southwest corner.
And that's solid hammock
Northwest
right
corner.
there.
I will note-
Wait,
I just wanna
wait,
note-
I'm trying to, as you've got time for rebuttal, and I know that the council's asking questions of witnesses, so I don't want to confuse the issues. I want to make sure council's done asking questions of witnesses, and then.
No, I just
follow
want to
the right
clarify,
process.
though, the fill area is on US 1 as well, that we're proposing. It's not on, just for
Well, let
clarity.
me ask you a question. If the fill area is on US 1 too, what are you doing between there and the old road?
Not US 1, sorry, Old Road.
oh,
Old
okay. I'm
Road, I
thinking,
apologize.
Okay.
Okay. Thank you.
All right. Anything else from council? Jennifer?
I'd just like to ask a question of Daniel. Daniel, how many key webs have you done?
That's a good question, too. I would say more than 30, less than 50,
And they've been throughout the lower keys, upper keys, middle keys?
from Key West to North Key Largo.
Thank you.
Yeah.
Thank you. I was going to ask that. Thank you, Jennifer. Are there any other questions or comments from the council? Okay. Let's see. Bart, would you like to?
We have to get anybody signed up testimony in support, and then anybody who's in
Okay.
opposition first.
Okay. Is there anyone in the audience that would like to speak in support of this appeal?
I think Marnie
I
said
have
no
no
one
one
signed.
signed up for this item.
Hearing none, is there anyone in the audience that would like to speak in opposition of this appeal? Marnie, anyone signed up?
No, sir.
Hearing none, very good. Thank you. All right, Bart, if you would like to close?
Yes, and just to clarify on that answer, and we can pass this around, it's actually in the actual submittal as part of our appeal. The potential developable area, and it is not capable of actual development, is that little gray line right there. It is not capable of development. So we're proposing a reasonable development. We've obtained the state permit. We have a qualified biologist that's done numerous Key Web scores. He's gone through, provided justification for each of his scores. You're determining whether that score is reasonable or whether it should have been rejected. We believe that we provided evidence that it is reasonable and that you should overturn the rejection and accept the score that was created by our biologist. And with that, I thank you for your time, and go Canes.
Thank you. Does staff have a closing? Daniel? No? Jennifer?
I'm all set. Thank you.
Very good. Well, council, do we need a discussion? Do we want to make a motion based on the testimony and the evidence that's been presented tonight? Deb?
Well, I'll make a motion, but I'm going to have to, because it's one of those negative, positive things, is I want to reject the appeal I want to stay with staff's original decision.
Okay, move to deny the appeal.
Move to
Move to
the-
deny the appeal. Thank you.
So there's a motion to deny the appeal. Is there a second or discussion from council?
She said she had a negative and a positive, so.
Well,
what was
I
the-
just
That's-
didn't know how to make sure I was wording
She
it
was-
properly. I'm denying the appeal. That's what I want to
Denying
do.
the appeal. Well, because it seems to me that there's a discrepancy in building and not building, and staff is saying you can build on it. And what I'm understanding, what I think I'm understanding is there's a discrepancy in what somebody thinks is a reasonable home versus not reasonable. And staff has already said that they can do it. So I'm going to go along with staff's and second her motion.
So there's a motion and a second on the table. Marnie, will you please call the roll?
Councilmember Deb Gillis.
Yes. Is that the correct answer?
Councilmember Anna Richards.
Yes.
Councilmember Steve Friedman.
Yes.
Vice Mayor Sharon Mahoney.
Yes.
And Mayor Don Horton.
Yes.
The motion passes 5-0.
We are, you guys ready for me? Sorry.
Let's do it.
I was hopping in, but I wasn't sure you're ready.
Nope, we're off to the last one. I think people.
Yep, we're still in quasi judicial. This is tab E. It's a resolution of the Village Council of Islamorada, Village of Islands, Florida, considering a request by Corey Sherber, applicant, to abandon and vacate a portion of Tide Avenue right-of-way, as shown on the sketch of description as drawn by Massey Richards Surveying and Mapping LLC, dated May 31st, 2025, reserving to the village all rights over any public utility easements and providing for an effective date. Council, again, before we begin, if you can disclose any ex parte communications, this includes both who you spoke with as well as the substance, as best you may recall.
All right. Anna?
I'm going to say Corey Sherber, Roger Young, Lee Young, and, yeah.
We've addressed everything, we're good.
Yeah. No, I just have to say who I've spoken to.
And as
So-
you mean the substance to the best you can recall? Any of those?
Well, the substance is, if you look at the drawing, my initials are on the drawing. I did the drawing. So I'm very aware of the property.
Does that mean you have to recuse yourself? Does that mean she has to recuse herself if she's connected in that way? Just out of curiosity? I stumped him.
Is your work finalized on this?
Yes.
Is there any contingency in payment or open payment regarding whether or not this gets approved?
No.
Give me 1 second while you guys are going through your.
I'm
ex parte.
sorry.
Okay,
It's okay.
Sharon,
You guys go ahead.
you want to disclose?
No, I know one.
No one, okay. Steve?
No one except staff.
Okay, very good.
go
Deb
too
will be back in a minute. I spoke to Roger Young because he was the neighbor of the applicant, so that's all. So you look that up, John, and we'll wait for Deb. And we'll play the Jeopardy game. She has nothing to disclose.
You guys
It's
are
on
on
the
the
record.
You guys went too fast for me.
Yeah.
I have nothing to disclose. Except I feel better.
Okay, you can't blame being late on me now.
No.
Me. Y'all can keep going.
You can blame it on me.
No, that's quite all right. It's all good. We want to be on the
Why
up
don't
and
we
up.
proceed?
That's why I said, why don't we just keep
proceed?
going?
Because you can, even if you have, I think you can be here, but I'll get an answer by the time we vote.
Very good.
Thank you, Council. Jennifer DeBobrian, Planning Director for the Village of Islamorada. I'm here tonight for the road abandonment request for Tide Avenue. Corey Sherber, the applicant, has submitted the application for a right-of-way abandonment, seeking to abandon and vacate a portion of the village-owned right-of-way containing approximately 1,600 square feet of Tide Avenue at the northwestmost point of Tide Avenue, as shown on Exhibit A of the sketch description in your packet. During the public notice process, a letter was sent to certified mail to the adjacent property owners located within 300 feet of the proposed right-of-way abandonment. The property was posted, and notice was posted in the local publication. As of the writing of this report, no comments have been received. The adjacent properties surrounding the requested road abandonment petition are within the residential single-family R1 zoning district. The area proposed for abandonment is a paved and improved portion of the right-of-way known as Tide Avenue and is currently being used as the end of Tide Avenue. All of the property surrounding the area requesting to be abandoned is owned by the applicant. The applicant seeks the abandonment as described above in accordance with the procedures set forth in Section 50-56 of the Village Code of Ordinances. The applicant has listed the following reason for the proposed abandonment. The surrounding parcels have unity of title. Village staff has determined that the requested abandonment of right-of-way is consistent with Chapter 50, Article 4, Abandonment of Rights-of-Way and Easements of the Village Code. And pursuant to Code Section 50-56B, all affected property owners are required to agree to the abandonment. And please note that the applicant owns the only property that will be affected by this abandonment. The Florida Keys Aqueduct Authority Board of Directors provided a letter with no objection. However, the Florida Keys Aqueduct Authority have facilities located within the area of the requested abandonment, and the applicant will be responsible to relocate the water main and meters under an FKA permit. The Florida Keys Electric Co-op has not provided any letter regarding the abandonment of the right-of-way. The village's wastewater department and fire department have reviewed the requested abandonment and have recommended the following conditions of approval. They must maintain fire department access width of 15 feet to within 50 feet of the front door or sprinkle the building. If any gates are proposed, clear width of 15 feet required and a Knox box system access required. If approved, all utilities will be relocated at applicant property owner's expense, and affected stormwater capacity shall be corrected at the applicant's property owner's expense. If ownership of the subject property transfers from the village to private ownership, the parcel that gains additional property area is subject to the assessment of ad valorem property taxes based on the assessed taxable value. This has the potential to increase the village's general fund revenues from ad valorem taxes in the future. Staff has reviewed the request for the right-of-way abandonment and determined that the request complies with the applicable provisions of the Code of Ordinances. Staff recommends that the council approve with the following conditions the proposed right-of-way abandonment application by adoption of the attached resolution. And the conditions are, must maintain the fire department access with 15 feet within 50 feet of the front door or sprinkle the building. If any gates are proposed, clear width of 15 feet required and Knox box system access required. If approved, all utilities will be relocated at the applicant owner's expense. Affected stormwater capacity shall be corrected at the applicant owner's expense, and the applicant will be responsible to relocate the water main and meters under an FKA permit. I'm here to answer any questions you might have.
Thank you so much, Jennifer. Is there anything the applicant would like to state?
Do you have any questions about?
You got to step to the speaker. Sorry to do that to you, but your name and where you
We
live.
also just need to make sure they were sworn in. I'm not sure that they were sworn in.
Were you sworn
Yeah,
in?
but I don't know.
You were
that
here.
they-
Yeah.
But did you raise your hand and get sworn in?
Yeah.
Okay.
He did, okay.
So basically, as far as the relocation of the utilities go, nothing's being relocated, but the water main and the sewer is being shortened so that the utility companies will still have access to it in the right-of-way, the new right-of-way line. So, like, as far as the expense of it, it's not that big of a deal. We're just shortening it. I'm building a new house there. I have to run new services anyway, so those would have had to been done either way. So, I guess that's all I got.
Okay. Let's see, are there any questions from council for Mr. Sherber? No? I got one question. Are you going to remove the paving? I'm
Yeah.
assuming it's paved up to your property line.
Yeah, it's paved into it partially. We're gonna remove that, but it's gonna become driveway. So it's gonna essentially be the same, just at a different pitch going up to the house.
Okay.
So, yeah.
All right. Steve, did you have anything?
And you have no objections to any of the conditions that were mentioned?
No, nope.
And that's
Okay.
mostly for fire access, is that right?
All right. Then is there any testimony from anybody in the public in favor of this request?
I have no one signed up.
Okay. Hearing none, are there anyone that would like to oppose this request?
I also have
Okay.
no one signed up.
Jennifer, do you have anything else to add?
I do not.
Very good. John, do you have anything you'd like to add?
Yeah, since this is quasi judicial, Councilwoman Richards will need to recuse on this.
She'll recuse herself, okay. So you got to fill out that pretty little form. Oh, yeah. You've got a couple of days to fill that out. Okay. Hearing no further testimony, do I have a motion to approve the abandonment of the right-of-way?
I'll make a motion to approve the abandonment.
There's a motion on the table. Is there a second?
Second.
Very good. Marnie, will you please call the roll?
Councilmember Deb Gillis?
Yes.
Councilmember Steve Friedman?
Yes.
Vice Mayor Sharon Mahoney?
Yes.
And Mayor Don Horton.
Yes.
The motion passes 4-0.
All right. Is there anything else that we need to do tonight for the good of the village? Okay. I hear motion to adjourn. Meeting is adjourned. On time.